Hi, sorry, I wasn't sure whether we were live then. Hi, everybody. It's great that we are live on this really great webinar for union reps from the TUC. My name's Anna. We'll be joined today by Jo Seery, who is a solicitor at Thompsons, and we'll be hearing from her shortly all about the latest updates in employment law. So, just to remind you a little bit about how we run these webinars, you can follow along with live captions. If you click the green button below me here that says click for captions, that will open the captions in a new window. It's great to see so many of you in the chat on the right hand side, introducing yourselves and telling us a little bit about where you are, what kind of workplace you're repping and your union. Please also use the chat to exchange some tips and ideas with other reps. We will also be awarding a digital credential today for everyone who joins live. A digital credential is a great way to show what you have learned and show what you've heard about today, and you can share it with your members, your fellow reps, with your employer. So do please look out for that in your emails after the event. Right, so today we've got Jo Seery from Thompsons Solicitors. We're working in the background to try and get her camera to come on, but she is here. And if we don't get the camera working, I promise we will include a picture of her in the email that we send out afterwards. So do bear with us, but we will be able to hear her loud and clear. So I am going to switch to her PowerPoint and hand over to you, Jo, to introduce yourself, and we can get going.
Well, welcome everybody. I'm sorry you can't see my picture, but I think that's a blessing in disguise, frankly. Anyway, it's lovely to be here on what seems to be a lovely sunny day right across the country looking at your messages. So I'm going to go through the employment law update. If I can start with the introduction page on the next slide, please. Unsurprisingly, there has been very little, I think, in the way of employment legislation in the last year. And we have been rather under threat of a bonfire of workers' rights. Not surprisingly, the union members are facing something quite controversial, and the government is attacking unions. Well, I think it's a fundamental attack on the rights of trade union members to strike. So what I want to do in this session is I want to start off by looking at the legislation and look at some of the legislation behind these threats. Then I want to go on to look at some of the compensatory awards, which have increased against a background of high inflation, before then coming on to look at some recent case law. And some of you may well be aware that there is a backlog of decisions that are awaited in the courts. So I'm going to look at some of those judgments and look what's going to come ahead that you can all keep your eye out for. And then finally, I will finish on some of the consultations which the government has launched. So I hope that covers everything that people were expecting from this session. So I'll turn now to the next slide. So what I'm going to cover is the minimum service level bill and the retained EU law revocation and reform bill, and then I'm going to come and look on to the private members bills, but I'm only going to do that very briefly because obviously the priority is looking at the strikes minimum service levels bill, which is on the next slide. So you can see that this god-awful bill was introduced on the 10th of June in the House of Commons. And what it does is it supersedes the transport strikes minimum service level bill, which had been introduced in October 2022. It enables the Secretary of State to make regulations which would require minimum service levels during a strike in all the following sectors. So that would be health, fire and rescue, education, transport, nuclear decommissioning and border security. And what the bill will mean is that employers in these sectors will be able to identify workers who are required to work during a strike in order to ensure that there are minimum service levels provided. Now, this bill clearly widens the scope of the original minimum service level bill from transport into other sectors. But also, instead of requiring trade unions and employers to meet minimum and reach an agreement on minimum service levels, the minimum service levels will now be set by the Secretary of State. The government launched 3 consultations in February in the ambulance, fire and rescue and passenger rail sectors. Those consultations have now closed, so we've got to wait and see how they're going to inform any regulations once the bill is passed, and this is assuming the bill is passed, and I'm going to make a point about that shortly. So turning to the next slide. In summary, the provisions of the strikes bill will require employers to give the union a work notice, and that work notice will then identify the workers who are required to work and who will be needed to work during the strike in order to meet the minimum service level. So there's going to be workers identified in those workers' notice, and the employer just has to be able to serve that on the union no later than 7 days before the strike action is due to begin. Now, before giving a work notice, the employer is required to consult the union about the number of employees who are required to work and what work needs to be performed during the strike. However, there's no obligation on the employer to follow any representations made by the union over this. So what you can see from this bill, is, if you can turn to the next slide, is that if the union, and these are the important points really, the impact of the bill cannot be overstressed. If the union is judged not to have taken reasonable steps to ensure its members adhere to the work notice, then it loses its immunity from being sued. So basically it can be sued. It's not clear what taking all reasonable steps means and what the union would be required to do. Secondly, employees who are identified in the work notice risk being losing their protection from automatic unfair dismissal if they don't comply with the work notice. So if they say, well, I'm not going to work during the strike, I'm going to go on strike, then they lose their automatic protection, which currently applies if they take industrial action for a period of 12 weeks. The Secretary of State, when making the minimum service regulations, is only required to consult such persons as they consider it to be appropriate. So before making a decision as to what the minimum service level will be. So these are things that are quite unknown really as to how these elements of the Act are going to actually work in practice. Now, this is a very timely employment law update because just this week on Monday, the House of Lords put forward a number of amendments which were debated in the House of Commons. So they put forward a provision which would require the government to carry out a consultation which must be reviewed by both Houses of Parliament before it can use its power to create the minimum service level regulations. It put forward an amendment which would prevent the unions from being sued for a failure to take all reasonable steps, whatever they may be. It put forward an amendment which would protect employees so that they wouldn't lose their right to be able to claim unfair dismissal if they refuse to comply with the work notice and continue to work during the strike. And it also put forward another amendment to expand the group of the lists of employees whom employers shouldn't target when they're identifying who should be on the works notice. Now, unfortunately, looking at the debate on Monday, nearly all of those failed apart from the last one. So what will happen now is that now the Commons have rejected the House of Lords amendments, the bill will now go back to the House of Lords for another debate, and sometimes this is often called ping pong, where it goes between the two houses to try and identify, reach an agreement on the actual terms of the bill. But given there's only one amendment that's been accepted, then it seems likely that we're nearer to the bill being passed as legislation. So that's a very gloomy outlook to the start of this session, but I think it's important people are aware of the potential impact of this. So turning on to what I hope is going to be better news on the retained EU law revocation and reform bill. So some of you will remember that when the bill was presented in September 2022, the intention of the government was that all EU subordinate legislation, so things like the working time regulations and TUPE, would be revoked at the end of the year. Sorry, just bearing with me because my computer has just said the battery is low, so I think I've sorted that. Sorry.
Jo, so just we've got a little pause. Can you just put a little bit of distance between you and the microphone? It's just popping a little bit, but otherwise the sound is lovely and clear. But just if you move it away from your face a little. Can you hear me now? That's good. I'm sure audience will tell us if there's an issue. But yeah, right. let's give it a go. Okay, so just recapping there. Sorry about that interruption. So the government was rather hoping to get rid of all EU secondary subordinate legislation, so things like the working time regulations and TUPE. They would be revoked, so they would be repealed at the end of the year. They'd just come to an end on what was known as the sunset clause. So that would bring a sunsetting on all the EU legislation that had been implemented. But what happened is that the government then set up a dashboard of all the legislation that would be affected. There was over approximately 4,000 to 5,000 pieces of legislation which would effectively just fall as a result of this sunset clause. So that's right across everything. It's not just employment law, it's right across the board, all legislation that's come from the EU, which is secondary legislation. But just last week, the government has backtracked on that and has actually removed the sunset clause. So this threat that we were under, that of all EU legislation that underpinned workers' rights would fall, has actually gone. And instead, the government has replaced it with a schedule of some 600 pieces of legislation, which will fall at the end of the year. Now, the good news is that it doesn't include as many employment rights. Well, it doesn't include any major employment rights at all within that 600 pieces of legislation that will end at the end. So we'll still have our working time regulations and we'll still have TUPE. But I'm going to come on to this and we'll see how the government is going to approach that when we get to the end of the slides and we look at some of the consultations. So we know enough not to trust this government, just to leave them well alone. I'll come on to indicate what kinds of things the government are looking at in terms of, particularly in relation to the working time regulations. Now, turning to the next slide. Some of you may remember in the Queen's speech a few years ago now that the government announced that it was going to introduce an employment bill. And that has never now seen the light of day. So what's happened is that majority of the proposals that we thought might be in the employment bill, like flexible working, legislation on tips, etc., now being taken forward by private members' bills. And the government has decided, quite unusually, to support some of these members' bills rather than have a proper employment bill that would protect workers' rights. So far, there is just one of the private members' bills that has received royal assent, and that was just a couple of weeks ago on the 2nd of May. And this will provide that employers
have a duty to ensure that all qualifying tips are allocated fairly to workers, and that includes agency workers, and make sure that payment is made in full no later than the end of the month in which the qualifying tip was paid by the customer. So what this will mean is that workers who don't get their tips will now be able to pursue a claim for unlawful deduction from wages. But as you can see from the slide, we can't get too excited about it because this isn't going to come into force until May next year, when we will all be, hopefully, campaigning as part of a general election. So we'll have to wait and see when that comes in. But that is one of the private members' bills that has received royal assent. And just turning quickly to the next slide. I've just put on a table there some of the other private members' bills and where they're up to. So you can see on the slide the Employment Relations Flexible Working Bill that will introduce some improvements. Not quite clear, government's not being very clear about whether or not that would be a day one right, but it would enable people to make flexible working requests, not just once a year, but twice a year. Had a second reading in the House of Lords, so it's still winging its way through the parliamentary process. The Worker Protection Amendment Bill will introduce back into law the right not to be sexually harassed by a third party. But you can see that is a long way down the chain. And I think recently the TUC has been calling on the government to pull its finger out in relation to this provision, which will improve and give better rights to workers in relation to sexual harassment in the workplace, to give better protection from sexual harassment. So we'll have to wait and see whether that sees the light of day. The neonatal care leave and pay bill, and that I was just looking just before I came on air. There's been a recent announcement that this doesn't look likely to come into force until 2025. So even though it's been given royal assent, it's not got a date for royal assent. So that means it's awaiting royal assent rather than being given royal assent. But that doesn't look likely for another couple of years. So they're clearly putting that one off until after the election. The carers leave bill, that's had a third reading and again should just be waiting for a date for royal assent, as I'm not aware of any amendments to that. That would give 1 week's unpaid leave to carers. And the Protection from Redundancy and Pregnancy and Family Leave bill, again, that's another one that's waiting royal assent. But as we can see with this government, awaiting royal assent can be sometime in the future rather than anything that's imminent. And there are, a number of bills that go forward, not just in relation to employment. So again, it remains to be seen whether these will actually see the light of day. But I thought it's just interesting to see what was in the pipeline. Turning now then to compensatory payments. These have all just been increased recently. So these rates here, the rate of the statutory week's pay for calculating statutory redundancy pay and a basic award for unfair dismissal has increased from £571 a week to £643 a week. So what that means is that if somebody's entitled to the maximum redundancy pay, which is 30 weeks, would give a maximum redundancy pay of £19,290. The minimum basic award, which applies where somebody is unfairly dismissed by reason of the trade union membership or activities, or as a result as acting as a health and safety representative or a pension scheme trustee, there's a minimum basic award there that has been increased to £7,836. And then in terms of the limit on compensation for unfair dismissal, so some of you will know that when you bring a claim in an employment tribunal claim for unfair dismissal, a tribunal, there is a cap that applies, and that is the lower of 52 weeks pay. So that's your annual pay, or 105,707 if you're lucky enough to earn that much money in a year. So In terms of statutory benefits, they too have also increased. So from £156.66 for statutory maternity pay, paternity pay, adoption pay, and shared parental leave pay to £172.48. Statutory sick pay is also increased to £109.40, still well below what the TUC and a lot of unions campaigned for, particularly throughout COVID, and which continues to be an issue for most unions. The statutory sick pay increased on the 6th of April and the statutory maternity pay increased on the 2nd of April. Don't really know why there's different dates for those. Turning to the next slide then, in terms of injury to feelings awards. So this is where somebody brings a claim for discrimination and is entitled to claim compensation for the injury to them that has been suffered as a result of the discrimination that they've been subject to in the workplace. So this isn't based on earnings, this is an assessment of the impact of the discrimination and how that has affected the individual who has been subject to the discrimination. And the case law has established that there are different bands of awards that a tribunal can make. There's a lower band that has now been increased from £990 to £1,100 to £11,200. So that's usually awarded in cases for one-off acts, but you can see that the band is a wide-ranging band, and there's not been any latest statistics produced recently about what levels are usually granted, the average levels that are awarded in an employment tribunal. The middle band is increased to 11,200 to 33,700. So those are cases where there's like a long-standing or slightly historical discrimination that's been going on, or more serious types of discrimination, so more than just a one-off act of discrimination. So it might be the way a policy has been applied. And then an upper band which goes from 33,700 to 56,200, and these are for the most severe cases. It's strange to talk about being severe and less severe cases because all discrimination is of course unacceptable and equally severe, but this is the way that the courts quantify it when they're awarding damages for injury to feelings. Turning now then to the next slide on the national minimum wage. Those rates are set out there. These increased from the 1st of April. So the age 23 and over increased to £10.42 with effect from the 1st of April. And you can see the other rates there. I'm just now conscious that I need to speed up a bit to get through the case law. So that's pretty much all the law on employment law recently anyway, and I want to now look at some of the case law. But turn to the next slide. And the one after that, sorry. So looking at the cases, redundancy is obviously looming large. And certainly at Thompsons we're getting asked more and more to advise on cases where redundancy is creeping up, and that's probably not surprising in the current economic climate that we find ourselves in. And I just want to put that in context, just to set out that there is a leading case on redundancy, which sets out 5 principles of fairness that the employer must adhere to when they're making workers redundant in the workplace. They must, first of all, warn the employees. They must then consult the employees and the unions where the union's recognised. Thirdly, they must adopt fair selection criteria. Fourth, they must apply the selection criteria fairly. And fifth, they must consider suitable alternative employment. Now, I'm sorry I haven't put that on the slide, but it occurred to me as I was going through these cases that these cases really drill back to the importance of those key 5 fair principles. So in the case of Loving Angels, this concerned a care assistant who provided living care to a vulnerable person. The vulnerable person was then moved to a care home in May 2020 during the COVID pandemic. And so the care assistant requested from her employer that she be put on furlough, but the employer refused and said there's no work for her. She was subsequently dismissed for redundancy and received a redundancy payment, but she brought a claim in the tribunal claiming that she'd been unfairly dismissed because the employer had failed to properly consider a period of furlough and that the employer had also failed to adequately consider her appeal. Now, the tribunal upheld her claim. What they said was that in July 2020, a reasonable employer would have given consideration to whether the claimant should be furloughed. And the employer said, oh, well, I'll appeal this. So they appealed it and said that that's not the purpose of the coronavirus job retention scheme, which applied at that time. And the EAT said that the employment judge was entitled to conclude that the possibility of furlough should have been properly considered. Furthermore, the employment judge was entitled to apply the same approach to furlough as it would do to any possible other alternatives to dismissal that an employer might reasonably, in appropriate circumstances, make, irrespective of whether or not there are exceptional circumstances. So you might be thinking, well, why is she banging on about the coronavirus job retention scheme? It's all over. But I think the case establishes a really important point, and it's a reminder to employers that they have got to fully explore alternatives before they actually make somebody redundant. So even though it looks as though this case on the facts isn't relevant, it's very relevant because the court is essentially saying it doesn't matter what exceptional circumstances that the employer feels that they are in, they have still got to go through that fair process, and particularly in relation to the requirement to consider alternatives to redundancy. They've got to do everything they can. They must fully explore those. So I think that's quite useful if you're representing members who might be at risk of redundancy. Turning now to the case of Mogane. So this case concerned 2 Band 6 nurses who were on fixed term contracts. And the trust called Miss Mogane to a meeting and said that she would be made redundant because her contract finished before that of her colleague. And then they spent the remainder of the redundancy process trying to find suitable alternative employment. There was no suitable alternative employment, and as a result, she brought a claim in an employment tribunal claiming that she'd been unfairly dismissed for redundancy. The employment tribunal said that the employer, there was a genuine redundancy situation, and that, as the employer couldn't find suitable alternative employment, then the dismissal was fair. But she appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal upheld her appeal. It said that when they're considering, it considered that where the selection criteria effectively determined who was going to be made redundant, then consultation should take place before that decision was taken. So where there is a pool of one, then the employer can't just go, oh, well, there's a pool of one, I won't bother with consultation because it's pointless. Because what the court said here is that the purpose of consultation is to enable genuine and meaningful consultation at the point at which the employee can potentially influence the outcome. But they can't influence the outcome if the employer's already made the decision based on the criteria. So what happened here was she was selected for redundancy because of the need to renew her contract, and the need to renew her contract was the reason why she was selected. So the Employment Appeal Tribunal said, well, the employer's still got to consult with the individual at a point at which she can put forward suggestions as alternatives to the prospect of being dismissed for redundancy. So this establishes the point that employers must consult even in circumstances where they've identified a pool of one individual for redundancy. Turning now then to Cook. This case involved an employee who was, where the company decided, here the company essentially decided that they were going to undertake a restructure, and that restructures required board approval. But this employee was fast approaching the age of 55. So what the employer decided to do was to forego that requirement. So they weren't going to seek approval by the board, and decided to hurry along his redundancy on the basis that this would avoid them having to pay £80,000 towards the pension scheme. The employer was called to a meeting for an initial so-called consultation meeting, and about 2 weeks later, he was then dismissed without notice. He turned 55 3 months later, and the Employment Tribunal upheld his claim for unfair dismissal. They found that the employer had failed to follow a fair procedure, and that if they had followed a fair procedure, his employment would have terminated after he'd reached 55. So he would have been entitled to the enhanced pension. However, it rejected his age discrimination claim, saying that the employer had what is known as a cost plus argument. So employers aren't allowed to defend a claim of discrimination simply by saying it costs us too much, but they can argue something else as well as costs. This is known as the cost plus argument. So what they argued here was that they were avoiding having to pay the additional payment into the pension fund, but they were also arguing that the regulator, this was a social housing company, disapproved of windfall payments, pension enhancements. So what they said was that was the bit extra that justifies having a cost plus reason for justifying age discrimination. So he appealed to the EAT, and the EAT upheld his appeal on a range of grounds, but the key one was that the tribunal had failed to balance the gravity of the discriminatory effect of his dismissal being in breach of the company's procedures as against the company's legitimate aim. So it failed to properly consider the balance in favour of the employee, given how severe the breach was in relation to the employer's failure to follow its own procedures when making somebody redundant. So that case is a reminder of the importance of employers following their grievance procedures, and not to, if you suspect of an employer advancing their procedures or doing away with their procedures simply because they want to get rid of somebody, then clearly that's a warning sign, and this case should help you in any of those negotiations. Turning to the next slide then, I want to look at dismissal. So dismissal and deciding when somebody is dismissed is crucial, obviously, to ensure that any claim is lodged in an employment tribunal in time. So in the case of Mika, this concerned an employee who'd been off long-term sick. So some of you may recall something similar in when you're representing members. So you get is called to a conversation with HR and is told that the employer is considering terminating its employment. And the conversation also moves around to the possibility of a settlement agreement being reached, but there was no agreement reached on that. And then a few weeks later, he receives a letter dated the 5th of February, but received on the 7th of February, which is marked without prejudice. So this is not to be considered in any tribunal proceedings and usually contains a settlement. And it said that there'd been an agreement on a mutual termination of employment, and that his employment would terminate on the 7th of February, which was the date that he got the letter. It also set out that they would pay him his holiday pay in lieu of notice, and that he'd receive his P45. It also said, enclosed actually, copies of the settlement terms and said that he would receive an ex gratia payment conditional on him signing. So if he signed the settlement agreement that was enclosed with the letter, then he would receive an additional payment. He didn't sign the settlement terms, but he did receive his notice pay and holiday pay on the 14th of February. He then brought a claim in the Employment Tribunal, and the Employment Tribunal said that the date of termination was the 7th of February, and that the letter had clearly demarcated when it was talking about dismissal and when it was talking about the settlement agreement. It said that on an ordinary, reasonable employee who had been aware of negotiations on settlement would have found that they were dismissed on the 7th of February and not on the 14th of February. The Employment Appeal Tribunal agreed, and it said that where an employee is dismissed in breach of contract, which arguably he was here because he hadn't been given any notice, he was just dismissed by letter, the expected date of termination was the date on which the dismissal was communicated, irrespective of whether or not he accepted that position or not. So this is important to look out for these types of letters where the employer might try and merge issues of without prejudice and hide a dismissal behind it. You need to act very quickly when you or your member gets a letter similar to that one that Mr. Meeker got in that case. Turning then now to something completely different in the case of Cox, which concerns contracts. So this case concerned the government's department to terminate check-off arrangements. The government made a big announcement a number of years ago now that they weren't going to allow subscriptions, trade union subs being deducted at source, so being deducted from the wages. The High Court in this case held that the arrangement, so what the union did was when they went ahead with check-off, they brought breach of contract claims in the High Court. And the High Court held that the arrangement originated by way of collective agreement was incorporated into civil service pay terms and conditions. And as there was no implied term enabling the employer to withdraw the arrangement on notice, the employer had indeed acted in breach of contract when it terminated the check-off arrangement. But the Secretary of State appealed on two grounds. The ground that by continuing to work and making arrangements to have subscriptions paid by direct debit, that the employees had waived their breach. But this was rejected by the court. They considered that in these circumstances, PCS, the union, had protested on behalf of its members against the withdrawal, and they'd also initiated legal action as a test case to test this particular point. So the court wasn't having any truck with the fact that the employees had in fact agreed to the variation of their contracts by having their subscriptions no longer deducted from their wages. Now, the second point they appealed on was that it was never the intention that PCS, the union, should get a benefit from this arrangement. So the parties, it said, had not intended the term to be enforceable by PCS as a third party to the contract. The court said that there was no intention to confer a benefit on PCS. The intention was only to provide a facility to the employees. Now, this judgment only came out yesterday, and it concerns 3 different government departments. And I think the main takeaway from this case for me at the moment is that where a union protests collectively on behalf of its members and keeps that protest alive, so where the employer is imposing changes to terms and conditions, there is less of a risk of the employer succeeding in an argument to say that the employees have accepted a variation. So I think that means that, you know, obviously it puts trade union members in a better position than it does individual employees who don't have the union to protest on their behalf. So I think this is a big takeaway from that particular case. Turning now to the next cases on the next slide. Now, the first case of Lloyd concerns a term time worker. And this comes on the back of the Brazil judgment, which some of you may be aware of. I think my colleague Brian Wilson discussed this one at the last TUC seminar that we had on employment law updates. In this case, the term time worker worked 3 days a week, and she was a learning support assistant. And the issue in the case was how should the employer work out whether or not she has been paid the national minimum wage. They said that the national minimum wage needs to look at her contract as a whole. Now, her contractual terms provided that she was entitled to the school holidays with pay. So the court decided that those school holidays counted towards the period over which should be assessed for determining whether or not she was entitled to the national minimum wage. So this meant a difference of between 40 weeks or 52 weeks. And the court said, well, it should be over the period of the holiday, so it should be over 52 weeks. But the case has gone back to the Employment Tribunal just to work out exactly what her basic hours were. Turning then to the judgment in McQueen, this case concerned an employee, sorry, that's on the same slide, who was disciplined. And the argument he ran is that he had a number of disabilities, Asperger syndrome symptoms, and hearing loss, some hearing loss. And this caused him difficulties in the workplace amongst his colleagues. He was referred to occupational health, who made a recommendation that any instructions that needed to be given to this employee had to be by email. He was subsequently warned for failing to follow those instructions, and then he was also subject to a discipline for performance issues. And he brought a claim arguing that he had been subject to unfavourable treatment for a reason arising from his disabilities. So he wasn't saying that he was treated less favourably because of his disabilities. He was saying that he was treated less favourably for a reason arising from his disabilities. So his behaviour was caused by the disabilities that he had. And as he was disciplined for the behaviour, then that meant he was subject to unfavourable treatment. Now, unfortunately, his claim did not succeed. The Employment Tribunal found that the reason he was subject to the warnings was not because his behaviour related to his disability, but because he resented being given instructions, being told what to do. And he appealed against that decision, but unfortunately, his appeal also lost. So it will be important in these cases to identify whether or not the treatment is caused by something that is linked to somebody's disability. The classic examples are where somebody is dismissed because of absence related to their disability, and whether the employer has acted fairly in those circumstances. So I'm not aware that Mr. McQueen is going to appeal that any further. So that seems to be a really disappointing judgment in his particular case. But these cases, as you will know, and has probably been repeated to you a number of times, all depend on the particular facts. Those are the key cases I wanted to cover. What I wanted to do now is just highlight some of the judgments that are awaited. So the first one on there is the decision of Agnew, and there are two key issues we're waiting a judgment on. The first one is when calculating holiday pay, does a gap of 3 months break the series, which means that an individual can't claim any holiday pay before the the 3-month gap. So say somebody takes holidays in December and they're not paid overtime for them, and then they take holidays in April, they can only pursue a claim for holiday pay that they're owed from April, because there is a 3-month gap between December and April. This judgment will consider that point and consider whether or not that gap should break the chain and prevent somebody from claiming their previous holiday pay that they were owed. It will also look at whether or not holidays should be taken in a particular series. So under the working time regulations, workers are entitled to 4 weeks holiday plus 1.6 weeks holiday, and then they may have contractual holiday. And this judgment will work out whether or not, when somebody books holiday, they're taking the statutory 4 weeks leave first, or the 1.6 leave, or the contractual holiday. And that's important because the case law has established that an individual has a right to receive their normal remuneration just for the 4 weeks leave, rather than the 1.6 weeks leave. So it will have implications for determining what somebody would be entitled to in terms of their holiday pay. The second case I wanted to draw your attention to is going back to the issue of redundancies. So employers are under a statutory obligation to notify the Secretary of State when there are collective redundancies. So when the employer is proposing to dismiss 20 or more employees as redundant, then they've got to fill in what is known as an HR1 form and notify the Secretary of State. Now, in insolvency, again, which is another big issue that's arising, we're seeing more and more companies become insolvent. An issue arose as to what would happen where the administrator failed to notify the Secretary of State. And the High Court held that they can be prosecuted for failing to notify the Secretary of State of collective redundancies. The administrator has appealed in that case, so we all wait to see the outcome of that. That was heard on the 8th of March, but I'm uncertain as to when we're going to get the outcome of that. But that could potentially be an important point when you're representing members where the employers become insolvent. Mercer, if this is the case where permission to appeal has been granted against the Court of Appeal's decision, which held that the right not to be subject to a detriment for trade union activities for taking part in industrial action didn't apply to those who were taking part in industrial action. So the court will consider an appeal against a finding that the protection from a detriment for trade union activities doesn't apply to trade union reps when they're involved in industrial action. So that's another important judgment. Turning to the next slide. A number of unions are bringing a judicial review challenging the lawfulness of the conduct of employment agencies and employment business amendment regulations. These repealed the previous provision, which provided that agency workers couldn't be brought in to cover striking workers. These amended regulations allow businesses to hire agency workers during an official strike, and so the unions are challenging this. That was heard on the 3rd and 4th of May, and so we're awaiting the outcome of that. And another important judgment, a case of Usdaw against Tesco's. This concerns another practice of fire and rehire. In this case, the individuals were entitled to an enhanced contractual payment, and the payment specifically provided that it was permanent. And the Tesco's then served notice on the individuals and said that they were going to bring their contracts to an end and issue them with new contracts which wouldn't provide for this enhanced payment. Usdaw sought an injunction against Tesco's, preventing from dismissing the individuals, and was successful at the High Court, but they lost at the Court of Appeal, and the Court of Appeal found in Tesco's favour. It held that it wasn't clear from the contract what was meant by permanent, and applied ordinary principles, which meant that all Tesco's had to do was to serve notice to terminate the contract. That was perfectly legal, the Court of Appeal said. And it also held that the injunction wasn't justified, and it was unaware of any other case where an injunction had been granted. So not surprisingly, permissioners for appeal, the union's appealing that, permission's been granted, and we're awaiting a hearing date in relation to that. And just finally and quickly, I just wanted to point out some of the consultations that the government is engaging in. So they have issued a consultation which has closed on how holiday pay should be calculated for part-year workers, basically trying to overturn the decision in Harper Trust and Brazil and go back to a percentage calculation rather than allowing part-year workers a right to holidays to over 52 weeks. There was a consultation on the ACAS Code of Practice on dismissal and re-engagement, but that's seen to be quite weak. It doesn't really add anything to what's already exists in law, apart from put it into a code of practice. And if the employers don't follow it, and there is an unfair dismissal, which is a big if, then the tribunal can make an additional award of 25% of up to 25% on any compensation that's awarded. So pretty much applying what already exists for other unfair dismissal cases where somebody's been dismissed on grounds of conduct. The senior president of the employment tribunals also issued a consultation on the use of panels in employment tribunal hearings, and what this will mean that discrimination cases will now be heard by a judge alone rather than a panel of 3 members who represent both sides of industry, so both for workers and employers. So that consultation came to an end on the 27th of April, so we're awaiting the outcome of that. And then just the other week, the new Department for Business and Trade issued consultations on reforming the working time regulations and TUPE. So even though they said, well, those legislation won't come to an end at the end of this year, as had been proposed under the reform of EU law bill, they are proposing to make some amendments. So they're going to remove the requirement for employers to keep records, which is a bit of a nonsense really, because I don't think many employers actually keep records and they're not really enforced. The second one is that they're going to combine entitlements to holidays. So remember before I talked about holidays, statutory holidays being split between a minimum of 4 weeks plus 1.56 weeks. They're going to combine those with the risk that they will change the way in which normal remuneration is calculated, because that was determined by case law to say that that should include overtime payments and any other enhancements. So they're going to consult on that. And they're also going to consult on the obligations to consult under TUPE. Currently, employers who've got less than 10 employees don't have to collectively consult. And what they're proposing is that under new provisions, they will exclude the obligation to collectively consult where the employer has less than 50 employees. So sorry, that's taken me quite a while to go through that. I hope that's okay. It's quite a lot, and I know there are quite a few questions, so I'll take some questions.
Thank you so much for that incredibly detailed and comprehensive update to employment law, Jo. I think you could see how appreciative the audience were. They, were very lots of comment as you were speaking. I'll let you catch your breath for 1 second just to update the audience on a couple of things. Yes, we are recording this event. We will send a link to the recording out to all of you who've registered. It will contain links to resources as well that are useful on this issue. So please don't worry if you have to leave early, or if you've missed any, we will make sure that gets sent out. We also had somebody ask about how they could be notified about future webinars. Yes, that is possible. You can join our mailing list. We will post it in the chat, but the chat moves very quickly. So don't worry if you miss that link. We'll also include that in the email that gets sent later today. Okay, I'm going to have a look at the questions. We've had quite a lot. We won't be able to answer all of them, but this is where we can offer another TUC service to you so that you can share your questions and get advice from your fellow reps. We have a website called unionreps.org.uk, which is a great place to post questions, just exactly like I just said, and get advice and answers from reps who might be in a similar situation. It won't be Jo answering them because she's obviously very busy in her regular job, but you will get to share your workplace issues with other reps and see what they're doing. I'm going to look at some of the questions we've got now for Jo. So thinking back to the first issue we covered, Jo, which was the minimum service levels bill, and you talked about the work notice within that. Will it name individual people or will it name posts within an employer situation?
Well, that we don't really know that at the moment. I mean, it's still very much at the early stages. So, you know, we're not clear what it means by identifying individuals, whether by name, post or whatever. So I'm sorry, I can't answer that just at the moment.
No worries. I appreciate that it is we don't know all the details yet, but I think it's still important that, you know, these are the kind of questions people have got so that we at the TUC know what we can give out to people going forward in regards to information. You talked about the sectors that this new legislation will cover, but do we know whether it's just public or what about the employee relationship? Will it be agency workers or freelancers who maybe fall into those sectors?
Again, I'm sorry, we just don't know how they're going to be defined because obviously they're going to set out this in the minimum service level regulations, I think, as to who they're all going to be covered by.
Okay, I think maybe what we'll do is we'll wait till more information is published from the government on this, and we at the TUC can issue some more guidance to that. Okay, we've had a question as well about 2P, and you covered that a little bit under the case law section, I think. We've been asked whether 2P law still exists, and if so, how soon after a takeover can staff be possibly laid off?
Well, so just repeat the beginning bit of that question again.
Does 2P law still exist? And if so, how soon after a company 2P, after the proceedings happened, how long after that can they lay staff off?
Right, so 2P does still exist. Make that absolutely clear. So when they're transferring rights, you know, you transfer with your contract and all your terms and conditions transfer over. In terms of how soon after the transfer, there isn't a period after which it's safe for the employer to dismiss people. The key issue is that whether or not the reason for the dismissal is related to the transfer, and that's the key issue really, is determining, well, what is the reason that the employer is getting rid of the workers? If it's to sort of harmonise terms and conditions, then that might be held by a tribunal to be related to the transfer, because those terms and conditions wouldn't be being harmonised but for the transfer. But there are all kinds of potential arguments that the employer can put forward, say that it's for an economic, technical or organisational reason. So it's not the period after that counts, it's the reason for any changes or the reason for any dismissals that is the most important thing. And if it's related towards the transfer, then you should be taking some advice.
That's excellent information. Thank you, Jo. We've had a question that we could probably spend an entire webinar talking about, but let's see if we can do a quick answer. We use the word meaningful a lot when discussing law and case law. What does meaningful mean? Can you give us an example or two?
Yes, well, an example or two. Well, meaningful consultation means that it allows time for people to put forward ideas, and those ideas are listened to, but they don't necessarily have to be accepted. So it's an engagement. It's not just going through the motions. So the ACAS have produced a guide on handling redundancies, and they set out what meaningful consultation means. And I was just going to see if I could just put my hands on that list. They had a list of things that they included within that, what consultation should include. But essentially, oh, here, I found it. So they said it means arranging regular meetings, being as open as possible, listening to views, genuinely considering suggestions, finding ways to avoid redundancies, deciding the best way to select employees, etc. Those are particular to a redundancy situation. So meaningful means that the employer has got to engage with what you are saying and not just ignore it and just go through the process, go, oh, well, I hear what you say, and then move on. It's very difficult because it's a fine line, but it has to be, take on board what people say, even if they're going to reject it, but take it on board.
That's excellent, Jo. Thank you. And we'll include a list to that. It's an ACAS list. We'll include a link to that in our resources that we send out. I suspect that the next question from that will be, what does genuine mean? But we could be here talking about that all day, I think. Another question about redundancy. So do the redundancy consultation legal requirements still apply if all redundancies are of a voluntary nature?
Yeah, so there is case law which says that where people volunteer for redundancy against a background of redundancies, so it's not just one individual who's volunteering because of an arrangement between the individual and the employer. So if it's set against a background of redundancies, there is case law which says that those volunteers count in terms of determining the numbers of people who are to be proposed to be made redundant and for whom the obligation then applies on the employer to collectively consult either with the recognised union if the union is recognised, or to the elected representatives if the union is not recognised.
Thank you for that, Jo. I'm just trying to find some more questions that aren't about the minimum service levels, because we obviously don't know a lot of detail about that yet. 1 second. You talked earlier about injury to feelings awards at tribunals.
Yeah.
Is this the same as Vento?
Yes, it is. Those bans are what are known as the Vento bans, because that was the case that determined them.
Thank you. And kind of secondary question from that is, where can we find the criteria, or what are the criteria for the different levels of injury to feelings awards?
Well, there isn't any criteria, because ultimately, when a tribunal is making a decision as to what to award, it has to award what is just and equitable, taking into account the impact of the discrimination. So what we advise is that individuals set out an impact statement and as to how the discrimination has affected them. So does it affect them on a daily basis? Does it affect their relationships, their ability to be able to sleep, their ability to be able to organise, the fact that they may have stopped carrying out exercise or any other hobbies that they may do. So it's organic, if you like. It's about how the impact of the discrimination on that individual, and obviously that's personal to the particular individual. So we always advise somebody to set out the impact the discrimination has had on them, their personal relationships, their hobbies, etc., as I've just explained, and then you get a whole picture and then try and decide whether or not that falls within those categories. It's very difficult, without any particular factual circumstances. It's just what is just and equitable, taking into account the impact on the individual. That's ultimately the bottom line, which is, I know, very vague.
And it's on a situation by situation basis, of course, because everyone's individual case is going to be different, right?
Yeah, case by case.
Yeah, so we've had a question about time limits on employment rights claims, and I think this is an area where people do get do have a lot of questions. And the viewer asks, or the viewer says that on the Thompsons Solicitors website, it talks about time limits on employment rights claims are 3 months minus a day from the alleged employment infringement. So if someone has been, how does then this time limit relate to an award? So if someone has been has got a pay claim like less than someone else on the same job for 2 years, can they claim the 3 months or the whole 2 years?
Right.
How
so
work
yeah,
around
how does
it?
that
It's
work?
kind of a
So,
double question here.
yeah. No, but I think I get it. So you've got a time limit to bring the claim. So that's a separate point. It's the 3 months less 1 day from when the person suffered a deduction. So when they didn't get the pay that they thought they were going to get, there has been a deduction. Then the last day, if there are a series of them, then it would be the last in the series, but we would usually advise people not to leave it too long because of some of the issues I talked about in the case law. We don't want the employer saying you've agreed to the lower pay, for example. So it's 3 months less 1 day from the date the payment should have been made. But the amount you can claim back is 2 years if there is 2 years loss. So if it's been so say for example where somebody transfers to a new employer, the new employer doesn't include overtime in the holiday pay, and actually they're chasing that with their employer and nothing gets resolved, and then they decide to put in, and this happens regularly, say every month for example, then in that case they can bring a claim and they can claim back the 2 years back pay. If an individual, probably the better example was if somebody isn't given their allowances, so if isn't given, say, a shift premium every month, and the new employer doesn't pay them their shift pay every month, then they will be able to claim back 2 years, so long as they get their claim in within 3 months less 1 day of the last date of the payment that they should have been entitled to. So if they leave employment, they should get the claim in within 3 months less 1 day of the date they were paid on their last employment, and they can claim back 2 years. But if somebody is not been paid their holiday pay and there is a gap of 3 months, so like the example I talked about before, if somebody takes their holidays in December and they've not been paid overtime on the holiday pay for December, they then take a holiday in April and they want to claim, and they're not paid the overtime and the holiday pay in April, and they lodge a claim in the employment tribunal in May. Well, they can't lodge it in May, but they lodge it within 3 months, June. So they lodge the claim in June. They can only claim the holiday pay back from April. They can't claim it back from December because of this rule, which says that if there is a gap in the payments of 3 months, then that breaks the chain in the series, and you can only claim for the holiday pay that was within the last 3 months. So what you need to establish is how often the payments are being made. If they're being paid monthly, then you're less at a risk of not being able to claim back holiday pay back over 2 years. If they're only paid intermittently and there are gaps of 3 months, then you're not going to be able to claim back everything over the 2 years. Does that better explain it?
It does. I mean, I think it is. It's like quite a complex question, and amazingly, I understood the process a lot more. So thank you for that again, Jo. I think we've got time for one more question before we wrap up. So if less than 20 employees are at risk of redundancy, should trade unions still be collectively consulted?
So is that more than 20?
If less than 20 are at risk of redundancy.
If less than 20, then no, the collective consultation obligations won't apply. But things to watch out for. Sometimes you'll get the employer saying, well, we're thinking we're going to make, they usually say like 19 or something like that, to try and avoid their obligations. So it's worth looking around. there's some quite helpful European case law, which will obviously the courts can still interpret that now and say, and that says that you can look back over a period and you can also look forward to see if there will be future employees included. So it's worth sussing out whether or not the employer is proposing to make any further redundancies in the future, and see whether or not they could be included, particularly if they're going to be dismissed within a 90-day period. Now, granted, the employer's not going to tell you this. It's worth having a look on Companies House, having a look in some of the press to find out what the intentions of the employer might be. But generally, if it's a clear mark that there's only going to be 16 that the employer is proposing to dismiss, then the collective consultations won't apply. If the employer is proposing to dismiss 25 employees but decides to only dismiss 16 of them, the collective consultations do apply, because there are more than 20 whom the employer proposes to dismiss, if that makes sense.
It does. Thank you so much, Jo. Again, every question I put to you, I think you've explained it so fantastically clearly for everyone. They're really complicated issues at times, and I'm wondering whether you've got one eye on the chat and you can see that people are very grateful and thanking you for the session today. So just before we wrap up, just to remind you all that we do have the unionreps.org.uk website for the questions that we haven't been able to get to, or for any other questions that you might have while you're conducting your role as a workplace rep. We all know that it sometimes can feel like you're quite alone, but you're not. There's loads of reps out there who can help you and who are there to offer support. And we at the TUC also will take note of those questions and use it to put information out to support you. Just a reminder that if you have attended this broadcast live, you will receive a digital credential from us at the TUC to recognise that you did. Please share that with your colleagues, with your union, with your employer, to show what you've learned. We will have one more Union Reps webinar from the TUC before we break for the summer, so look out for that in the following few weeks. We'll be advertising it soon. Thank you again to Jo for joining us. You were fantastic, and thank you for everyone in the audience joining us today. I hope you've enjoyed it as much as I have. See you again soon.